You guys see that?
Yep.
Okay, cool. Okay, so for those who don't know me, I'm Rachel Pritzker. I run Pritzker Law Group, which is a high quality legal services firm. We do real estate business and government relations in the greater Philadelphia region. A little bit about us. I run the firm with my twin brother, Adam. And again, we sort of specialize in real estate, um, development, government relations, and business. We've won a number of awards recently and throughout the years. So I say this just to show that we know what we're doing. And we don't do it for the awards, but I sort of pride myself on being very good in this area. I tell people know a lot about a little bit. So, um, this area I really know very well. Um, Today, we're going to talk about tax assessment appeals. It's sort of a hot topic right now, given the tax appeal deadline for filing tax assessment appeals is October 7th. It's always the first Monday in October, so it's the same time every year. So we sort of have this window between when people are getting their tax assessments and this appeal window, and it's always the first Monday in October. It just happens to be the 7th this year. Um, Basically, the way that this works is you should, or your client should in the mail get an appeal form, and with the valuation that should include what's called a first level review and also the formal appeal documents. If you haven't got that, if your clients haven't got that, let us know. We can still obtain that from the city and we can still file these on time. I get a lot of questions around what's a first level review. First level review is an informal appeal. It's an informal process whereby you can say to the city, hey, listen, we, got the valuation. We don't believe that, it's accurate. We want to give you an opportunity to look at it again before we file the formal appeal. The issue with it is that it doesn't have any teeth to it. So we do file that form with the formal tax assessment appeal. But if we don't file the formal tax assessment appeal, then if the city decides looking at the first level review, the FLR, that they don't want to make any changes, they are able to do that. And then you kind of have no teeth to be able to force them to, look at the formal appeal, work through the process and go to a hearing if need be. There's also times where people will say like, oh, well, I don't want to pay a lawyer to do this and I just want to do it myself or whatever. And they'll sometimes check like non-oral hearing. I've had people reach out to the Office of Property Assessment, OPA, before and say, well, OPA said if I click the non-oral hearing that I get through faster. As a general guideline, I never suggest, whether it's dealing with the city or anything else, where you have a process where they're making decisions behind closed doors. That's what happens at a non-oral hearing. They just make a decision behind closed doors as to what they think they should do on your case. And I don't think that that's ever a good idea. Transparently, I would never want anyone deciding anything without me standing there. So at a minimum, if you feel like you want to do this yourself, I tell you not to for a lot of reasons that I'll go into, but more importantly, don't ever select a non-oral hearing. Not a good idea. The way that our firm works is we will do a 15-minute free consult with clients up until the October 7th deadline. I tell people, please let me know ahead of time. Don't reach out to me like October 3rd, 4th, 5th, or 6th. If you have, you forget or you have a client reach out, like I'd rather you let me know and we'll make it work. But, again, like we do have to do a lot of work to prep with these and we do offer 15-minute free consults. So whether you think you have a good case or not, and that's true with all of our legal services, we'll always do a 15-minute free consultation, even if you're a repeat client, or it's a different matter. Rather, you just reach out to me and we'll go through it. A lot of times what we do is we look and we'll see, if you have an appraisal for the property, sometimes you do because you just went through a closing, you're working with a bank, they required an appraisal. Either way, we will connect you with an appraiser. We found over the last 2 years, specifically with this mayor's administration and with the process and the way that it's worked with the city attorneys and the evaluators, that getting an appraisal is the best way to negotiate the value with the city. I work with a lot of realtors. And while I appreciate like the MLS and market comps and things like that, the city doesn't appreciate them as much. So, when I say we want an appraisal, it's not because I personally want the appraisal, it's because that's what's been the most successful in negotiating these with the city and getting the biggest reductions possible. Pulling comps is great, but it just isn't, it doesn't move the city for whatever reason. So That's why we ask for appraisal. We'll connect you with different appraisers that we work with. We don't get any like kickbacks or anything from recommending them. It's just people that we've worked with over the years that have experience working with the city, the Board of Revision of Taxes. They're quick and efficient, and they also understand how the assessments work in the city. You're welcome to work with any appraiser that you want. You will, or your client will contract with them directly. We don't get involved besides saying here's people that you can reach out to. But it's really important, especially if you're not sure what the value is, or if you're not sure if you have a good case, it's really important to run it by an appraiser. If the property is assessed at $1 million or more, not that it's worth $1 million or more, it's assessed at $1 million or more by the city, you have to get an appraisal anyways. So, and again, it's something that we like to have to negotiate with the city. We don't turn the appraisals over right away. We don't file them with the appeal originally, but we do use them in order to help negotiate with the city. And 9 times out of 10, it's been really successful. That's why we do it. Another good indicator is a sale price. I had a client reach out to me today, actually a realtor reach out to me today and said that they closed on a property with their client and the sale price is less than what the city has it assessed at. That's a really good case for an appeal because they literally just purchased the property. It's assessed at more than what they purchased it for, and we can use the sale price in that instance, the agreement of sale, in order to negotiate that down. We still do have to file a formal appeal by October 7th, but there are instances like that where, we can use other things. And again, usually if they use bank financing, there's an appraisal anyways. And a lot of times we can just get them updated to reflect 2025. Once we file the appeal in October, we basically sit and wait for a while. We used to like reach out to the city right away, but we're still negotiating 23, 24, 23 and 24, and in some instances 22 with the city. So there's really no rush. Because we're lawyers, we reach out to the city's lawyers, OPA's lawyers, and deal with the lawyers directly. That way you're not dealing with just the evaluator, and you're not, we used to spend a lot of time figuring out who the evaluators, deal with the evaluator. We just deal with the attorneys. And then that way, if we need to coordinate with the evaluator, we can do that through them. It just has made this more streamlined and efficient. If you're not a lawyer, if you don't have those relationships, also going to be pretty challenging to work through this efficiently, just how the city is. We do use the appraisal if we have one. Again, we don't turn that over right away. We have some strategy how we handle these. And really our goal is to negotiate with the city. 9 times out of 10, we don't take these to a hearing. You will wait 1.5 to 2 years to even get a hearing, and you'll kind of just sit there. And the environment, for whatever reason, at these hearings is sort of very adversarial. It's very short, and it's not the best way to get a reduction for the assessed value. We have found that going back and forth with the city, providing the appraisal, allowing for a site visit if there's concerns around size or condition, are better ways to negotiate. We don't negotiate for clients unilaterally, so we don't sign documents on your behalf without running things by you. We'll basically say to you, hey, we were able to get a hold of the city attorney for this matter, OP's attorney and the evaluator. They're willing to reduce the value, from this to this. We think it's a really good deal because of this, and that. Please sign this document if you agree. We also, because of our relationships and our ability to understand the process, we will work with them to negotiate at least 2 or 3 years of the same value. That way you don't have to, and your clients don't have to file another appeal next year. The city is allowed to reassess real estate every year. But when we negotiate these, 2 or 3 years in the future, and at least we'll give you some breathing room, your clients some breathing room, that they don't have to worry about this, the next 2 or 3 years. That's also the value of working with our office versus if you do it yourself or you work with someone who may not know what they're doing. Additionally, again, we don't really want to go to the Board of Revision of Taxes for hearings. For those who know me, know I love a good administrative hearing. I go in front of the Zoning Board of Adjustment regularly. I go in front of the Board of Revision of Taxes. I go in front of the BLIR, the LIRB. However, if it's not fruitful to our case, I'm not going to do it. So, and again, I have no problem going to hearings. I love a good administrative hearing, but we found that the best way to get the value down and to be efficient with time and money for clients and ourselves is just to try to negotiate these ahead of time instead of waiting 1.5 to 2 years to get to a hearing just to get no result. People ask me what's a good case? And again, we offer 15-minute free consults, and they're with me personally because this is sort of the avenue that I do. I do almost all of our government relations work. The sale price is the best indicator if it was a recent purchase. If your sale price, again, is less than the city's assessed value, then that's a great case. If we can get an appraisal that shows a lower value than what the city has it assessed at, again, when you look at appraisal, it does look at market comps, it does look at condition. Sometimes it will also look at cap rate and rents if it's an income producing property. The city is supposed to look at size, location, condition, and use. It's also something we look at as well. If you have, all the properties on the block that are the same, like size, location, condition, use, or there are bigger properties or they're multi-units and yours is a single, if the condition of your property is worse than your neighbors that is just renovated, or I can see that there's building permits pulled and closed that were just renovated, those give us good reasons for both non-uniformity and overassessment. Also, if you have an abatement that wasn't implemented correctly, the land value shot up randomly, the brick value shot up randomly, those are also good cases for an appeal. And I always tell people that if you're not sure, or if, we are waiting on appraisal, it's better for us to lock in the appeal, because we can't fix the timeline issues as easily as we can just withdraw or see if we can negotiate with the city. And if we don't get where we need to be, we can always withdraw it. It's better to have something as a earmarker to sort of add value than not. And again, it's really hard to get stuff implemented, or work through something if it was filed late. We settle most cases. I've settled, I think, over, I don't know, $15 million worth of reductions in the last year alone. We just did one last week that we got a reduction from 9 million to 2 million. So that's huge. I wish I did that on contingency instead of hourly, but that's my problem, not yours. And, I'm really open and transparent with this stuff. I like to win. I like to be consistent. I like to be able to produce results for people. And I'm the first person to tell you if I think you don't have a case or not, because we're not a consulting firm where I just give out information and I'm like, best of luck. I actually have to do all the work with you as well, and work through these relationships with the city. I'm going to talk about tax abatements really quickly, because even though I've been doing this almost 15 years, tax abatements are still something that people really don't get and understand. And I know that realtors especially are kind of the front line of defense with their clients. They go to you guys first. And so I just always like to add this with the tax assessment conversation. And honestly, whenever I do any sort of educational seminars, I always talk about the tax abatement. The tax abatement is based off the building permit. So every timeline for a tax abatement is based off the building permit issuance date, which is on the top right or top left corner of the permits. It's not based on like when your contractor feels like it. It's not based on when you feel like it. It's not based on when the work was done. It's not based on how many units are in the building. It's literally based on the date that the building permit was issued. That's the only thing it's based off of. I tell people that if you always get them filed within 30 days from the date that the building permit was issued, then you'll never mess up an abatement. If you start to play around with the timelines or you listen to anybody else about this, typically you'll miss it. And then again, we can fix it. I fix a lot of these in front of the Board of Revision of Taxes, but it's a long timeline and it's not, as guaranteed as if you just do it correctly the first time. Our office does do not only full-time expediting, but also we do file tax abatements for a very cheap flat fee for people, because people mess them up so often and then they don't know how to implement them either to make sure that they show up correctly on the city's websites and then your tax bills are correct. Again, timeline, think 30 days, you'll never mess them up, or just reach out to us and we'll handle it. Not theoretically, actually the timelines though, new construction and commercial is they has to be filed within 60 days from the date the building permit was issued. For a rehab or an addition to an existing structure, it's within the same calendar year as the building permit was pulled. So it's not within one full year. If your building permit was pulled in 2024, the abatement application has to be filed on or before December 31st, 2024. But again, because this is like a little confusing, if you just think 30 days, file your abatement application with your building permit within 30 days, you'll never mess it up. There is a whole process for abatements. None of this is automated. So a lot of people don't realize that just because they sent something into the city, or a client did, or a buyer did, and you represent, or the seller did, and you represent the buyer, there's a lot of people mess up how this goes. Just because it's mailed in or just because it's emailed in doesn't mean that it was implemented, doesn't mean that they got it. And so we always make sure that we email it in. I don't mail in anything to the city ever since the pandemic. That's just not been a great way to do it. It's also hard to track it if it's not in an email. So we email all these in to a very specific person at OPA, because sometimes it can get lost. We then make sure that we have everything that's needed, including the building permit, the abatement application, all the tax information that's required, et cetera. There are times where people don't set up their tax accounts with the city correctly. That can hold stuff up. We deal with tax clearance. We also make sure that we help you work through tax clearance. There's times where people will purchase a property from somebody else and they'll have an abatement, but it's stuck in tax clearance. We actually need the person who applied for it to clear their tax clearance before a new person could get the benefit of the abatement. And then, yes, the abatement runs with the property, but there are a lot of these steps that are not automated at all, and they have no technology around them. And I've asked that of the city, I don't know, probably 100 times in the last 10 years. Why don't they have it similar to Eclipse? I don't know. They don't have it. It's very manual. So we follow up, follow up, follow up, follow up over and over and over again until it gets implemented. Once the project is done, you actually have to submit the CO with the certificate to commence to OPA. And then we have to work with the specific evaluator for that area to be able to implement it into the city system. And then we double back with revenue to make sure that they have the same information that OPA has. Because a lot of times, if that's not done, then the tax bills are wrong. It's wrong on the city's account. And if it's not correct on OPA and revenue, it's just not correct. And so we've worked through it, especially when there's condos, especially when there's planned unit developments, especially when you have multiple townhouses on one site. Some of it can get a little bit more complicated. Last thing I'll mention about this is that a lot of times the estimates that people put on a building permit is just an estimate with your contractor. So there are times where let's say they're doing a renovation, they thought it was going to be 300 grand. This out of the third happened, it ended up being 350. We can actually get a supplemental abatement application implemented to include the additional $50,000 or whatever the number, these are just made up numbers, whatever the number is, so that you can get the full value of the cost of construction. A lot of people don't realize that's possible. It is, again, something that we do as well in our office. Um, if you file it late, I always tell people that just let me know as soon as possible. The sooner that you let me know that you messed it up or a client messed it up, the easier it is for us to fix it. It does take a long time to fix it. They are fixable. I have a really crazy approval rating in front of the Board of Revision of Taxes. Again, I'm like a one-trick pony. I've done the same type of law for a really long time. So like I do know what I'm doing just in this space. And so I'd rather people come to me with bad news as soon as possible and we can like work to fix it. If I don't think I can do it, I will tell you that. But if I think there's a shot, I'll, be very candid about how that works, timeline, things like that. A lot of times, again, if you just work with our office to get the abatement done originally, then we don't have to worry about filing things late. Also, if it's something that was kind of out of your control or something that one of your clients is taking on, we've worked a lot with realtors on different types of escrow agreements to be able to do closing, and then we can work through a pending tax abatement and things like that. There's a lot of solutions that we can come up with to help move things forward. I also, I get a lot of people saying to me like, oh, I didn't know you did this or that. I thought you only did zoning. I thought you only do this. I specialize in zoning and land use and government relations because I worked in city government, but our firm and myself and our other lawyers do a ton of different types of law. So I always tell people just reach out. We don't charge you for meeting with us, an initial conversation about it. Rather, you just ask us. And if we can help, we will. If we don't do that type of law, or there's some other reason we can't help you, I will try to connect you with someone else in the space that, we've worked with or that other clients have worked with that can help you. But we do a ton of all real estate related, government relations related, and business related work in the city and the surrounding county. So if you have any other sort of similar or adjacent issues, let us know and I'm happy to jump on a call. I know that was a lot of information. For those who know me, you'll know that I would like to tell you everything I've ever known about anything so I can be helpful, but kind of just want to pause there and happy to answer any questions that you guys have. Amen.
Hi, Rachel. Thank you so much for an incredible presentation as always. Jesse Frank has some questions in the chat box, but my question is, so I've said this before, you're one of the most esteemed real estate attorneys in all of Philadelphia, the
Thank you.
history of Philadelphia. I appreciate your wisdom and advice so much on all of our previous cases. So, the City of Philadelphia's Office of Property Assessment uses a CAMA system, computerized assisted mass appraisal, that has a secret magic algorithm that pulls in public data and variables and factors in a computation using a geographic market analysis to produce the citywide automatic assessments. which sometimes can be incorrect, inaccurate, or inflated because of many different issues or situations with the software. So no one knows what the computational formula that this camera system uses. Could we subpoena OPA and the algorithm to get whatever formulaic computation that they use for a specific property in order to analyze that specific data as you're kind of negotiating the assessment appeal?
So it's a great comment, and I will tell you the history of like OPA in the city goes back many, many years. There's been a lot of council members who have had hearings about OPA, who have filed suits, and there's like sort of a lot of information on this. It's funny, I was at a fundraiser with a councilman over the summer, and I was kind of like just complaining to him about my experience with OPA, and um and he had said to me, well, it's funny because we did a briefing in council and we asked OPA to explain to us how they do assessments. And the conversation went on for 2 hours, and the council members still had no idea how OPA does assessments. So I say that to say that there have been many attempts to try to get this information from OPA, to try to get them to put on their website how they're assessing real estate, what the calculations are, what the formulas, and there's been really no like teeth to getting them to do that. I think that the only way to really do it would be to like, file again a massive lawsuit, and that would take a very long time to get them to give out any of that information. What we've found to just be helpful is to kind of negotiate with our lawyers and get the values reduced with appraisals, because kind of going at, unless we're going to do some massive class action suit, which I think maybe would happen one day, just the timing of getting all that done, the costs associated with it, would just be difficult. So while I listen, I'm the first person that would love transparency and honesty from, I don't know, all city agencies. I think from like a individual property owner representation perspective and like efficiency perspective, it just wouldn't be something that would be feasible. But I think it's something worth bringing up to council members, because I know that they still are struggling with understanding, how OPA is doing whatever OPA is doing. And when I first worked in council, I worked for Councilman Dom, as you know, and we met with OPA like 900 times to try to understand what they were doing and what the camera system was. And it was nearly impossible to get straight, solid answers from the former appraiser, assessor for the city, and the current one. And you really need a mayor and an administration that wanted to focus on this and wanted to like dig in on this, because you can't compel, even city council can't compel the mayor's administration to do things. They have to want to do this stuff. So without some sort of outside lawsuit or whatever, I don't know how. And if you Google it, you can see many council members over many years for a very long time have brought this same issue up. And it's just a matter of, I guess, someone really wanting to like fight it and deal with it.
Mm.
So we just try to work, for the individual homeowners and property owners to just get a result. And again, 2 or 3 years in the future, so that you don't have the headache year over year.
Thank you so much, Rachel. That's why I say Rachel for mayor. But
Oh my
I
gosh.
is unacceptable in a city like
I
Philadelphia
agree.
that uses an automatic citywide assessment module on a secret algorithm. No
I
one knows
agree.
in city council, our jurisdictional district city council people that have land use controls, have councilmanic prerogative, are not able to compel the appearance and hearings of OPA representatives. We need to subpoena the algorithm, understand what the formula looks like using Freedom of Information Act. So I would say I would jump onto that class action lawsuit if you want to start it. So good luck.
Yeah. I'm I'm with you on that. I'm not a class action attorney, but no, this is something that's been discussed a lot, and I agree with you. I think that everything should be transparent, especially in our city. I'm going to jump to Jesse's questions. Do you recommend the homeowner continue to pay the taxes while the appeal is in process? Okay, this is a great question. I'm sorry I didn't mention this in my presentation. So the way that it works is that when you file the appeal timely, you only have to pay taxes on the amount of last year. So you pay the same as the year before. And thank you for bringing this up, Jesse. Um, the other thing that our office does is we will issue a letter to your financial institution, your bank or whatever, to let them know with the city code and the rules so that they're aware. Because I've seen times where certain financial institutions are just not in tune with the local laws and rules. And so they'll pay the taxes based on the new assessment, not the one from the year before. So we do offer that as a service. That letter, I'm doing an appeal for my sister, her home right now in Graduate Hospital, and I had to deal with her bank. I think she has like TD Bank or whatever. But yeah, you have to pay the same amount as the year before once we file your taxes on time. But yes, you have to pay the taxes. It's just not at the increased amount. So thank you for bringing that up. Do you recommend getting an approved tax appeal for a property prior to applying for a tax abatement? So, approved tax appeal.
I can
I
kind
don't
of
really
go.
understand. Yeah, sorry, go ahead.
So, I have a client who is appealing their property's assessment. It was just purchased. It is wildly overassessed, um, like multiple X's. Um,
I believe
but
it.
it's a property that they want to improve. They want to renovate, um, but they don't want to have an approved tax abatement on a property that doesn't have a revised assessment, because I feel like they fear that with the new assessed with the abatement would be based on the current tax amount, its current assessed value.
So it's a great question. It kind of works separately, to be honest. So, and here's the major issue. The tax assessment appeals, it takes us a year and a half to resolve them, and that is not going to a hearing. So when I tell people like we don't want to go to a hearing and we work to resolve these, it's again, it's not because I don't want to do a hearing. I love a hearing. It's that it takes so long to even get to a hearing, and also they're not fruitful. So we try to negotiate these, but because the city's so backlogged, it's taken us a year and a half to get through 2023. Okay. So timeline wise, what I would recommend is they file the tax assessment appeal. They're going to be paying on the year before's value. They're not going to be paying on this new value. However, it's, if they wanted to wait for their to do the work on the property, they could. They're just going to wait probably a year and a half to 2 years to like then like do the file for the abatement and do the work. The abatement shouldn't really have anything to do with the tax assessment appeal, because again, they're going to be applying for paying on the year before. The way the tax abatement works is they take the whatever that you put in for your estimated construction cost, they put that in if it's implemented correctly and if it's applied for correctly. They put in what's called the taxable exemption column. It's the same place that like the homestead exemption is located on OPA's website, property.phila.gov. And they basically subtract that from the overall assessed value and then times that by the millage rate. And that's what you pay from a tax perspective. I would tell you that if they were trying to time it to get the tax appeal done and then the abatement, they're going to be waiting like 3-4 years to do all this work. So what I'd probably recommend is they file the tax assessment appeal on time. They move forward with getting a building permit for the whatever improvements they want to do, file the abatement application on time, and then work with our office or whoever they want to work with to make sure that it's implemented correctly. Because my concern would not only be the appeal, but it would be making sure that it's implemented correctly to produce the right sort of tax liability. And there's a lot of sort of competing things here, but you're not going to get through your tax appeal in a timely manner. It's just not possible. So unless they want to hold up all the work for that, there's ways to kind of do it at the same time and make sure that the values are correct. And we
Okay.
work through that a lot with people, a lot.
Now,
It's just,
with a homeowner that maybe owns their home, uh, uh, outright, uh, how would it work? Like if they file and you said that it can take over a year for these to be approved, um, does it is that retroactive? Is that savings that's agreed to? Is
yeah,
that retroactive? So they'll get a credit?
yes. Yeah, so what we do is one of two things. So again, they don't pay on the new assessment, they pay from the year before. When we do get a result and a reduction, they basically will either pay the difference if it goes up slightly or if it's less, or what we do is we either get them to put a credit or we'll do what's called a refund petition, where we actually get the city to kick back money if there was any overpayment from the year before. But again, it takes so long to resolve these that we get them resolved first and then we deal with the payment. And again, they're not paying on the updated value, they're paying on the year before's value. So we'll do a credit or again, a refund petition, just depending on the client's preference.
Great. Thank you.
You're welcome. Any other questions? Okay, I'm going to put the best way to reach me in the chat. It's not my cell phone, so if you text me, I won't answer. I'll just ask you for your email and then I'll email you. But contact at pritzkerlg.com is the best way to reach us. And like I said, if you have any questions related to this or anything else, even if you think it's silly or you think it's whatever, it's not silly. I only know this stuff because this is all I do. And I'd rather have you guys reach out and ask me than not. And again, if we can help, we will. And we like to make sure that we have willing participants because we do run the process in any of the legal services we do. We do them sort of soup to nuts. And so we like to make sure that you guys are aware of what we're doing and that we can work collaboratively on these kind of things. Also, just because it's worth mentioning, we do need to be connected directly with your client. If it's not you, if it's a client or the property owner, as long as they put in writing that they are okay with you being on a call, I'm happy to have you involved. It's just that it breaches confidentiality and privilege, and we're lawyers, so we have to uphold these different sort of ethical rules. And so as long as the client in writing says, or the potential client in writing says it's okay for you to be on the call, I'm happy for you to be on the call. It's not like me personally doesn't want it. I just, for ethics reasons, I have to make sure. The other last thing I'll say is we usually kick you out a link and say, hey, have your client or fill this form out. We have to run conflict. There's times where I've represented a lot of people over the last almost 15 years. So I have to make sure that there's no conflict, especially if it's a landlord tenant issue or whatever. Any tax assessment appeal, there's no conflict because the adverse party is the city of Philadelphia. But just in general, just so you know how our process works, I just like to follow rules to make sure everybody feels good and is protected. Appreciate everybody's time today. Getting this set up. I hope to see you all in person soon, and feel free to reach out if there's anything we can be helpful with. And I hope you have a great rest
Rachel,
of the day. It is
Rachel,
beautiful out.